All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning. Our first case today is Davis versus the state of Florida and Davis versus Dixon, numbers 21-1778 and 22-882.
Chief Justice, there are actually two cases here to argue. Do you prefer that we do each case individually with the appellant and the appellee, or do you prefer that I argue both cases up front?
Let's do them individually.
Individually, okay. Thank you, sir. My name is Stacey Biggert, and I represent Leon Davis in his post-conviction cases. The first case for argument today is SC 21-1778, which I will refer to as the Headley case. I will focus my argument on Issue 8, which is also duplicated as Issue 10 in SC 1779, the BP case. The court prioritized expediency over Mr. Davis's constitutional due process rights when the court denied post-conviction counsel's request for a competency evaluation at the hearing on the state's motion to strike mental health mitigation. As a threshold issue, this claim is preserved for appellate review. Mr. Davis's case can be distinguished from Caratelli versus State, which is the case cited by the state in their answer brief, and it's also the case that this court regularly cites for preservation issues. In Caratelli, the defense attorney made a statement that if he had more peremptory challenges, that he would use them. He did not actually ask for more peremptory challenges. In response to that, the judge did nothing. The judge said nothing. Mr. Davis's case is more analogous to Colvin versus Williams, which is the case that Caratelli distinguishes. In Colvin v. Williams, the plaintiff objected when the defense tried to enter evidence about the plaintiff's prior litigation experience. In response to this motion and argument, the judge said, "Fine," and then did nothing to prevent the defense from putting the disputed matters into evidence. The Caratelli court distinguished Colvin because the court's verbal response, "Fine," and his subsequent conduct, doing nothing to prevent the defense from putting the issues into evidence, left no doubt as to his ruling. In Mr. Davis's case, post-conviction counsel made a clear request for a competency evaluation. Like the judge in Colvin, Judge Jacobson acknowledged the request and asked the state to respond. And like the judge in Colvin, the court left no doubt as to his ruling. He heard from post-conviction counsel, and he heard from the state, and then he granted the state's motion to preclude mitigation evidence. Post-conviction counsel's motion should have been taken seriously, but the discussion at this hearing was not about Mr. Davis's competency. The discussion at this hearing was about expediency and moving this case along. I would want to say from, yes?
I'm struggling to find where you discuss Caratelli in your initial brief. Can you point me to it?
I don't discuss it because I don't argue that the case is in no way preserved. The issue was brought up by the state in their answer brief when they claimed that it wasn't preserved. So I am responding to that argument, sir.
Okay.
None of the delays in this case were Mr. Davis's fault. His first evidentiary hearing was scheduled for January 2020, and it was continued because his attorney resigned from his job. That wasn't his fault. He was assigned new counsel immediately, and 2 months later, COVID-19 hit. And there were months and months and months of court delays that were not his fault. Even once the courts were open again, there were issues with transporting prisoners from DOC, and jails wouldn't accept prisoners from DOC. And even if they would possibly allow them there, they wouldn't allow them to appear by video, or they wouldn't allow their attorneys to see them. Again, these delays were not Mr. Davis's fault. But back to counsel's request, and that it should have been taken seriously. While the court was not obligated to take counsel's representations as conclusory, those representations should have been in the court's consideration. In Drope v. Missouri, the United States Supreme Court held that an express doubt by one with the closest contact with the defendant is unquestionably a factor that should be considered. The person with the closest contact to Mr. Davis was his attorney. Post-conviction counsel also satisfied the requirements of 3.211. Yes, this was an oral motion at this hearing. However, the judge acknowledged her motion and asked the state to respond. The state responded to the motion, and there were no arguments made at the hearing that this competency evaluation motion was not put in writing. Post-conviction counsel addressed Mr. Davis's demonstrated history of mental illness and his waffling between allowing and disallowing mitigation. Competency goes to the heart of whether a defendant has the capacity to make a cogent, legally binding decision. Not only did the court not take Mr. Davis's counsel's reputation seriously, but the court also ignored significant red flags that created a record of Mr. Davis having a difficulty consulting with his attorneys within a reasonable degree of rational understanding and a doubt as to whether he had a rational as well as a factual understanding of the proceedings. This is the standard of Dusky v. United States, and it's codified in Florida Rule of Criminal Procedure 3.211. The court was well acquainted with Mr. Davis's case, and he was aware that Mr. Davis struggled with understanding what was happening in his case. And his lack of understanding often led to paranoia and distrust of his attorneys and suspicions that they were hiding things from him. In fact, the court received numerous letters to the clerk, and letters to the bar to this effect. Earlier in the post-conviction process, the court was very patient with Mr. Davis. He would bring him in for hearings when normally they probably wouldn't transfer a capital inmate to court for these types of hearings. He would allow Mr. Davis to appear by phone, and he was very patient in trying to help him understand his post-conviction process and what was happening. However, as soon as the COVID shutdown happened and all the cases started to get backlogged and delayed, and then there was a push to get this case moving, the court's earlier concerns about Mr. Davis's due process rights evaporated, and they were replaced by a rush to get this case to the evidentiary hearing. The question that was before the court was whether the court had a reasonable ground to believe that Mr. Davis may be incompetent, not whether he was incompetent.
So what's the factual predicate for that you assert that gave the court the reasonable grounds that you believe the court had?
The red flags that I discussed, the experience that he had with Mr. Davis for months, knowing that he did have some serious issues understanding the proceedings and understanding the factual basis of the proceedings, and that competency is fluid, and if counsel was representing that she had concerns about his competency.
But what were her concerns related to?
Her concerns...
Wasn't it about his indecisiveness, about whether to do mitigation?
That's a red flag, Your Honor, I would argue, and also she mentioned that his mental illness...
But that seems to me to be very, very thin. I mean, people vacillate on issues like that. That's not uncommon. That's not a sign of a lack of competence. That's just, it's a high stakes situation, and people will vacillate. That's if vacillation was pointed to incompetence, we'd have it all over the place. And so I just think that's extraordinarily thin. What am I missing about that?
That it's one red flag of many, and while one red flag may not seem significant...
But wasn't that the heart of it?
No, it was also his mental illness and his record of mental illness that she cited at the hearing. And plus, this court was aware of other things. I mean, he had handled this case for 10 years, and he had many encounters with Mr. Davis, and so he had a record and a reason to believe that counsel was making this motion.
Except he didn't
in
believe
good-
that.
I think that the record, well, I'm sorry, Your Honor, the record actually shows that he didn't take it seriously because he wanted to get this case to an evidentiary hearing. The discussion
I
that...
think imputing a bad motive like that to the judge is pretty extraordinary.
No, sir, I don't think he had a bad
Well,
motive.
I don't know how you characterize that, other than saying the judge is going to ignore what he's required to pay attention to in order to do something to expedite the case, and that's imputing a bad motive to him. It seems to me.
No, sir, I'm not...
I mean, maybe that's not your intention, but you look at it objectively. That seems to be a reasonable takeaway.
Well, his behavior at the hearing was that when the discussion came up about this, he was very concerned with the state's argument that if he granted this motion, that the state would then have to hire experts and that it would take much longer in order to do this, and that would reschedule the evidentiary hearing. And the record is pretty clear that at every pretrial hearing we had, he was extremely apologetic, especially to the state, that this evidentiary hearing wasn't going forward, and I think he was under a lot of pressure. And I can't put...
What
sorry.
rule are you asking us to adopt when a judge expresses frustration with, delay that I think is within the range of judicial discretion in terms of moving a case forward? I mean, what is it that you're asking us to do with this?
The judge needs to put the defendant's due process rights ahead of expediency.
No one is arguing that, counsel, and I think it's, I guess, and I have the same reaction that Justice Kennedy has. Those two things are not necessarily, at least on this record, in conflict as far as I can tell. A judge has every expectation to move a case forward expeditiously, and if a judge is, you're saying it's not in the record, you're saying that the judge's behavior, you're making comments about what your assessment of the judge's demeanor was below, and you're asking us on that basis to say that the defendant's due process rights were violated? That seems, to use a word that's been used already today, really thin.
Thank you, Your Honor. I'm not making comments about his demeanor. I'm making comments about the way the hearing was conducted, and that there wasn't the request from counsel was not taken seriously, and the entire discussion was about getting that case to a hearing.
Part of the dynamic here, counsel, it seems to me, is that we know that there are cases where this competency issue will kind of be raised that doesn't have much of a foundation, and then, but the attitude is, well, why not? Why not do it? May not be a sufficient trigger for doing the evaluations, but why not? But that's not. That doesn't mean it ought to be done. That doesn't mean that because sometimes we'll say why not, but we can just go ahead and do it because somebody's kind of raised this flag, whether it's based on anything that's substantial or not. That doesn't mean it should be done. And if the judge is saying, look, we've got these other things that we need to move this forward, and the judge is making a decision that it's not warranted, and I'm skeptical, but I understand why you're arguing it.
Thank you, Your Honor. I also don't think that there's anything in the record that shows that counsel did not make that motion in good faith, and proceeding with a possibly incompetent client that would violate his due process rights. So, Your Honor, I would also like to address one additional issue on this case. I would like to talk about issue 2, if you don't have any further questions about the competency issue. Issue 2 is actually an ineffective assistance of counsel claim for failure to object to the court's gratuitous comments to the jurors about the evidence in this case. So during jury selection, trial counsel did not object, and in fact he agreed to, the court's comments to the veneer that the injuries to the victims in this case were so uniquely gruesome that he was giving a warning to jurors that he had never given before during all of his time on the bench. So the comments singled out Mr. Davis's case to the jury. The court said, "This case is truly not for the faint of heart. The photographs alone are graphic." The court then explained to the jury that he handles all the first-degree murder cases in the circuit, and in his 16 years on the bench, he's seen a lot. He also told the jury, "I don't normally give this kind of presentation." He singled out Mr. Davis's case as more graphic and gruesome than any other case. The court's purpose, his statement of the reason why that he did this and the reason why counsel said he did not object, was they wanted to determine if potential jurors could cope with the emotional aspects of this case. Trial counsel didn't object because he said he agreed. However, it was trial counsel's job to keep the court from packing the aggravation with its commentary. The court could have accomplished this goal of bringing in the jurors and showing them these graphic pictures without making his own comments on the evidence. Trial counsel should have objected to these comments because the judge was basically saying, "I've handled all the cases and all the first-degree murder cases in the circuit, and I've sat through 16 years on the bench, and this case is so bad that I have to do something that I've never done before." He's basically addressing an aggravator before it even goes to the jury.
But counsel, I mean, this is a horrific case. I mean, this is more like an acknowledgement of the reality, this horror of what happened. It's hard for me to see how these comments are going to affect the jury in a way that they would not be affected just by the facts that cry out. I mean, it's because it's the nature of it, and I mean, anybody would understand that. I mean, we look at a lot of cases, and there are a lot of horrific cases. That's the kind of the nature of the cases that come to us. Not all of them, but a lot. But this is one that definitely does stand out because of the way the murders were the victims and the way the murders were committed. So again, I understand why you're arguing this, but I have a hard time seeing how this really makes a difference.
Your Honor, you're right. The scene and the crimes were horrendous, and that's why the judge did not need to add his commentary on this because, I mean, there was already an uphill fight here on this case.
Doesn't the court then follow that up by reminding the jury about the presumption of innocence? Because you kind of omitted that from the statement. Doesn't the court then go on to describe the burden of proof and the presumption of innocence?
He does do that, Your Honor.
Okay. So it seems really odd that you would select that part of the court's instruction and omit an acknowledgement that the court followed up a statement that essentially says, you are going to see evidence of the immolation of two people. I'm preparing you for that. And remember that the defendant benefits from the presumption of innocence. If that's not a more complete statement of what the court really said, tell me. Because it seems to me like your statement to us takes out of context the allegedly objectionable remarks and doesn't candidly put before our court what the court actually said. Can you correct me if I'm wrong?
You're not wrong, Your Honor, that he talks about the presumption of innocence, but he also, and that wasn't in what you just said, he stated that this is the worst I've ever seen. So this jury that they're picking right now is not only going to be his guilt-phase jury that determines guilt or innocence.
And what of Justice Kennedy's question that however prejudicial the impact of these statements may be, that prejudice pales or is at least equal to the prejudice or negative effect of the actual pictures, the actual evidence in this case?
Because it's putting the weight of the court behind the evidence and his comments behind the evidence.
Okay. And help me understand what we would review this for.
You would review this for ineffective assistance of counsel because counsel did not object to these statements when they were made.
And your position would be that the lawyer's decision not to object in light of that conversation is the constitutional equivalent of your client having had no counsel under Strickland?
He didn't have valid representation during that hearing because his attorney allowed this to happen.
That seems like a hard sell.
Wouldn't the remedy have been, if there had been an objection, excuse me, wouldn't the remedy have been something kind of equivalent to what the court ended up saying anyway, reminding the jurors about the presumption of innocence?
That could be a potential remedy, Your Honor, but the cat's also out of the bag. I mean, the court has already told the jurors what he thinks about this case and what he thinks about this evidence.
So it's a mistrial.
Yes, Your Honor, that's what would happen. And you have to pick a new jury.
You're down to 1 minute of your
thank you, Your
rebuttal time. Thank you very much.
Thank you, Your Honor.
Good morning. May it please the court. My name is Marilyn Beckie. I represent the state of Florida. Respectfully, I think counsel is being somewhat unfair to both the trial judge and the post-conviction judge. A little context is important in determining the decisions that, I'll start with the competency issue, that the post-conviction judge made. This case indeed was long in coming to an evidentiary hearing for a variety of reasons, some of which were out of Mr. Davis's control and some of which were out of the court's and the state's control because of the COVID-19 pandemic. Nonetheless, there was a significant amount of litigation that occurred in the post-conviction context. I apologize that I don't have the record site, but during the during the hearing regarding the state's motion to strike the mental health mitigation claims, counsel did not specify that she was requesting a competency evaluation. The comment was more akin to, Mr. Davis understands that we've done some mitigation investigation. He does not want mitigation evidence presented at the post-conviction hearing. I told him that you, referring to the court, might want to do a colloquy with him. There was no indication that he did not understand the proceedings, that he was not able to assist his counsel, that there were some factual elements that he needed to participate with. Based on the request that was made during that hearing, the conversation then became, well, if this is an issue that now Mr. Davis is going to start saying that he wants to now present mitigation, then the state would have to hire some experts and do some evaluations, and we're already 3 years approximately into this litigation. That was why the state filed the motion to strike those two claims on both of the cases, because initially mitigation claims were presented, but there was never any expert reports provided. There was no factual basis for the claim. There was no legal basis for the claim at this point after we had litigated it for a number of years, and that was the impetus for the state to file those two motions. It is consistent with Mr. Davis's position all along that he did not want mitigation evidence presented. He did not want, well, I shouldn't say that. He did not want extensive mental health mitigation presented, either below, after his convictions, or during the post-conviction proceedings. Mr. Davis appeared at the post-conviction evidentiary hearing. He testified in the BP case. His answers were contextually appropriate. He didn't appear to not understand what was going on. He knew who the players were in the courtroom. If at any time his attorney or the judge thought that there was an indication that Mr. Davis was not competent, that issue could have been raised right there and then, because as counsel stated, competency can be fluid. He could be incompetent at one point and then competent at another. So there is no preclusion from how many times you can raise a defendant's competency. I'll move on. If there's no questions with that issue, I'll move on to the issue regarding the comments of the trial judge and the photographs. This is a particularly horrendous case. There is no doubt about that. The judge never said that this is the worst case he saw or these are the worst photographs. He did say they were particularly graphic, and they are. What he was informing the panel of, the large panel of, was this procedure is going to be slightly different because of the nature of the photographs in this case. We are going to show you photographs in individual voir dire that isn't ordinarily done. So he was explaining to the jury, this procedure is slightly different, and this is why. And Mr. Norgaard didn't object because Mr. Norgaard wanted those photographs, or representative photographs, shown to individual voir dire, individual jurors, because they did not want to get into the middle of a trial and these jurors see those photographs. And as Mr. Norgaard testified at the evidentiary hearing, he has been in cases where once a jury sees horrific photographs, he loses them. And he did not want that to happen. So he wanted to somewhat desensitize potential jurors to the impact of the photographs that they would be seeing. And they did see them. They saw the representative photographs, and they saw more at trial. So he did have a strategic reason for wanting potential jurors to see those photographs. The judge's comments were not overly prejudicial. They weren't a comment on Mr. Davis's guilt or innocence. They were a comment on the fact that these jurors were going to see something that is difficult for anyone to see. And we ask jurors to do very difficult things, and one of them is to look at photographs that really no person should have to look at, unfortunately. So I don't think there's any issue regarding the judge commenting on the evidence, and there was no basis for Mr. Norgaard to object to something that he requested the court do.
So would you put this in the category of not ideal or affirmatively appropriate? Putting aside the prejudice issue.
I think it's affirmatively appropriate when all the parties agree to it, which was what happened in this case. Is with reference to showing the photographs, Your Honor?
No, in terms of the commentary from the judge, which is
I think it's appropriate. I don't think every judge needs to do it or has to do it, but I don't think there's anything particularly objectionable unless the defense counsel does not want the potential jurors to see that. There's, sure, could you object? Would it be reversible error? Probably not, because as been pointed out, the judge followed up that comment with an instruction of the presumption of innocence.
But in some ways here, it's actually consistent with the trial counsel's strategy.
Oh, absolutely.
I mean, it's not like, it's not at odds. So when the judge says that, it's the trial counsel's, it's like it's on the same theme that the trial counsel is trying to follow.
Absolutely.
And which does not, on the face of it, seem to be an unreasonable thing for a trial counsel to be concerned about and to be trying to deal with it in the way the trial counsel is dealing with it.
And that's what Mr. Norgaard had testified to at the evidentiary hearing.
I've been trying to isolate in the record the use of the word "this is the worst." Is it? Am I right that does not appear in the record? The court, in fact, did not say that.
The court did not say that. What had happened is during individual voir dire, Mr. Norgaard identified a potential juror who had served on a capital case previously. He did not want that juror on the panel, although I think she ultimately did appear on the jury. He was looking for a reason to strike her for cause.
Right.
So what Mr. Norgaard said was, as the judge said, these are some of the worst photographs that he's ever seen. So he was paraphrasing what the judge had said in the introductory.
Okay, but there was no judicial statement that this was the worst evidence the judge had seen.
Not that I could find in the record, Your Honor. If there are no further questions, the state would request that you affirm the denial of post-conviction relief.
Thank you. I just want to make a few comments.
Why did you tell us that there was a judicial statement that this was the worst evidence the judge had seen?
Because the judge said that I've been on the bench for 16 years. I've done all the first-degree murder cases in this circuit, and I've never had to do this before. That's essentially what the judge said.
That's not what, I don't think that's what you told us. I think you told us that the judge said this was the worst evidence he had seen, and that's just not in the record, is it?
But it's a paraphrase of exactly what he said. The meaning of what he said was that these are the worst I've ever seen, and that's why I have to do this with you today. Thank you, Your Honors. If you have no further questions, I would ask that you remand this case to the circuit court for a new trial. Thank you.
And you can feel free to take a minute or two to get your head together for the next one. Okay, and this case is also Davis versus State and Davis versus Dixon, numbers 21-1779 and 22-883.
Thank you, Your Honor. The second case for argument today is the BP case. And I'm going to focus my argument on issue 3, which is Mr. Davis's Strickland claim for trial counsel's failure to challenge the only evidence the state actually had to convict Mr. Davis of the BP crime. The BP case is not the Headley case. It is very important that you separate the facts of these cases. The BP case is a circumstantial evidence case. In BP, there's no eyewitness testimony that places Mr. Davis at the scene. There's no fingerprint evidence that places Mr. Davis at the scene. The only DNA evidence of record came from a cigarette that was found at the scene, and Mr. Davis was excluded as a contributor. In fact, the state had no case against Mr. Davis for the BP murders until Mr. Kwong testified that the same gun was used at both Headley and BP, and then the state put up witnesses at the BP trial from the Headley case that placed the gun used at Headley, the very same gun that Mr. Kwong said was used in the BP murders as well, in Mr. Davis's hand. The cross-examination of Mr. Kwong was critical for Mr. Davis's defense. Trial counsel's stated strategy for cross-examining Mr. Kwong was twofold. First, he wanted to show that Mr. Kwong could not actually identify Mr. Davis as the shooter. Second, because Mr. Davis bought a .357 Magnum from his cousin, he wanted to point out that Mr. Kwong could not determine if the gun used at both crime scenes was a .357 Magnum or a .38 Special. Both of these strategies are objectively unreasonable in this case. The first one, Mr. Kwong is a lab analyst. He sits in a lab and he analyzes bullets and fragments and case jackets. There's no way Mr. Kwong would be able to walk into a courtroom and point at Mr. Davis and say that Mr. Davis was not the shooter, or Mr. Davis was the shooter. The second one, the problem with the second strategy is ultimately it doesn't matter what kind of gun was used in these two cases. Whatever type of gun it was, the same one, according to Mr. Kwong, was used at both crime scenes, and eyewitnesses from one of those scenes put that gun in Mr. Davis's hand. The only reasonable strategy to acquit Mr. Davis of the BP murders was to challenge the ballistics match. Once trial counsel decided to concede the ballistics match, it was game over for Mr. Davis. So Mr. Kwong's ballistics match, coupled with the witness testimony from the Headley witnesses at the BP trial, convicted him. A reasonable attorney would not concede the state's only evidence against their client. A reasonable attorney would not stop investigating once he learns the state's experts testify that the bullets will match. And a reasonable attorney would investigate further, as he's required by Wiggins.
And I'm sorry to interrupt you, but there was testimony from the trial counsel that he did consult his own expert and that the evidence was unfavorable to Mr. Davis. Is that right?
Yes, sir, he did. He consulted a similar expert. He consulted another AFT theory of identification expert. But trial counsel can't just concede. There are ways that trial counsel could have challenged this evidence. Defense attorneys do it all the time. We do it with DNA evidence, even when we have a DNA match. We may question the DNA analyst on contamination in the lab. We may cross-examine them on chain of custody issues. We may cross-examine them on artifacts in the DNA reports that could also affect a match.
But if at the end of the day, I mean, if it all collapses and jumping through those hoops doesn't produce anything, it seems like it's just an exercise in futility.
Well, Your Honor.
I mean, and we don't, but people don't, there's no prejudice if it's an exercise in futility. And people don't get post-conviction relief because the lawyer failed to do something that wasn't going to produce the desired result. Sometimes they just got you. And there's nothing credible you can come up with to refute the gotcha. Isn't that correct?
No, sir.
I mean, put aside whether that applies to this case. There are cases like that, right?
Yes, sir. There are cases like that, but in this case, he could have challenged this forensic evidence. It doesn't matter what he personally believes about the AFT theory of identification. This was a circumstantial evidence case where the only thing they had to connect Mr. Davis to the two BP murders was that ballistics match. That's it. That's all they had.
But the deficiency, because you kind of, when you were talking before, you kind of transitioned from the cross-examination deficiency argument to the not doing enough to investigate kind of factually. And I just want to kind of clarify, though, that are you saying that he didn't, I mean, it's clear that you're arguing that the cross-examination was deficient, but are you saying that whatever counsel did in terms of consulting his own expert and getting the feedback that he did, that was also kind of a separate deficiency?
Well, he didn't prepare for trial. Like, he didn't prepare for his cross-examination. And, Your Honor, I mean, he didn't even have to necessarily retain an expert to help him cross-examine this witness. I mean, he mentioned that he was aware that there were other attorneys who were challenging ballistics matches. And he said that he was aware of the National Research Council's 2008 ballistics imaging report. There are things that he could have done to research and investigate and prepare to put holes in the state's linchpin evidence at this trial. And instead, he conceded it. And once he conceded it, I mean, there was no hope for Mr. Davis in the BP case, even though there was no other evidence that could place him at the scene.
This is, in the time that I've been on the court, and we hear these post-conviction cases constantly, and this, I'll call it Monday morning quarterbacking, that I guess is a necessity in post-conviction type of arguments. It's just something to difficult to deal with, like, because the conditions that existed at the time the case was being tried cannot be duplicated. And what went on through the lawyer's mind at the time, and the mood of the jury, the whole essence of the courtroom is there at the time. So it's hard to come back here, so many years later and say, you should have done this, you should have done that, you should not have done this. And that seems to me what we do constantly in these cases. But let me just ask you this question. I mean, wasn't the strategy of the state in this case that the same gun used in the BP killing was also used in the other case when the lady was shot to the hand?
Yes, sir.
And it was a .357 Magnum?
It was never determined exactly what kind of gun it was,
Well,
because the gun was never recovered.
He had bought a gun from his cousin
Right.
the day of the BP killing.
No, sir.
The
He
day of
bought,
the Hadley case.
I'm sorry, I didn't mean to interrupt you. He bought the gun from his cousin a few weeks before the BP murders took place.
Okay.
So it was not completely temporal. Like, it was a few weeks before the BP murders took place.
Didn't Mr. Norbert, the defense counsel, wasn't he able during cross-examination to get Mr. Dodd, the expert, to say that a 9mm could have been used?
No, he did not do that at trial. He did that was done at the evidentiary hearing. But my argument is it doesn't matter what kind of gun it was if the same gun was used at both scenes, because the Headley witness, he's already been convicted of Headley, and so the BP's the second trial, and there are Headley witnesses who testify that it was Mr. Davis at Headley, and Mr. Davis had the gun. So ultimately, whatever kind of gun it was, it's put in Mr. Davis's hand.
What if a .357 Magnum was used in the Headley killings and 9mm was used in the other case? That would tend to show there was a different person.
That's true, Your Honor, but the court, he couldn't determine that. That's one of the problems with this analysis was there was no gun recovered, so he could not do test fires, and a lot of the bullets that he was actually reviewing were fragments.
But even though a gun was not recovered, just bringing that out in cross-examination, that a different gun was used in one of the killings, that gives him some argument to make to the jury, even though he can't precisely prove it.
Right, but he could do more. He could talk about error rates, repeatability, the subjective nature of the match, the fact that there's no database that these examiners use. Like, it's not like fingerprints or DNA where there's databases. It's their head. It's like their memory of all the different matches that they've done over time. The fact that there was no gun recovered is important here because test fires are very important to the discipline. He could also have cross-examined him about the fact that he didn't take, there's no measurements in his discipline. You look under a microscope at striations and marks and visually measure them. Yes, sir.
Didn't Mr. Norgard successfully elicit on cross a statement from Mr. Kwan that there are at least 21 possible types of firearms that would produce 6 lands and grooves with the right twist? Is that an accurate statement of the record testimony?
I don't have it in front of me, but I believe so, sir.
Okay, so if that's accurate, and the thesis of your argument here is that the counsel, that Mr. Norgaard was constitutionally inadequate under Strickland because he didn't make the point or establish the evidence that is central to the defense that it could have been any number of firearms. How does that argument survive the fact that, in fact, Mr. Norgaard on cross elicited a concession from the expert that indeed there are at least 21 different firearms that might have produced this evidence?
Yes, I understand that, sir, but my argument is that it doesn't matter what type of gun it was. If the witnesses put whatever gun it was in his hand at Headley, and Mr. Kwong says that it was the same one, then you have to contest the match. You have to contest his actual match. And in order to find for Mr. Davis here, this court doesn't have to make some sweeping decision.
I guess you're going to have to help me understand how this does not contest the actual match from a Strickland standpoint. Again, let's keep in mind the standard here. You're saying that the concession I just read to you is equivalent to this defendant having had no cross-examination or no counsel with respect to Mr. Kwong's testimony. I find that hard to understand.
Because he got one concession out of him and he covered one issue, when if he had investigated further, as he was required to do, he would have actually been able to poke holes in the comparison and explain why there are flaws within the discipline that can he has to raise reasonable doubt. That's what he has to do. That's how you acquit a defendant. You raise reasonable doubt. And by poking holes in that evidence, just like we do with all forensics evidence whenever we're up against a wall and we have to fight a DNA match or any other thing, you poke holes in the discipline. You do everything you can to raise reasonable doubt, and that is not what he did. If there are no further questions, Your Honor, I would ask that you please remand this case for a new trial. Thank you.
May it please the Court. The argument in post-conviction with reference to the ballistics is essentially this. Mr. Norgaard didn't hire the expert that post-conviction counsel hired. That's essentially what the argument is. Mr. Norgaard testified at the evidentiary hearing that he did.
Well, was that expert even an expert in the subject?
No, Your Honor, he was not. He's not a ballistics expert. He is a respected scientist. He did have a number of questions and concerns about the scientific underpinnings of ballistics. But Mr. Norgaard testified that he looked for a viable expert that could attack the underpinnings, the scientific underpinnings of ballistics evidence, and he wasn't able to find one that he thought he could present at trial. And arguably, he wouldn't have been able to present the post-conviction expert because the post-conviction expert could not comment on, he was not an expert in ballistics. So he probably would not have been able to testify with reference to what Mr. Kwong's conclusions were. Secondarily, Mr. Norgaard testified that he did not believe that if he could not actually say that Mr. Kwong's conclusions were incorrect, that it would not be fruitful for him to start placing other experts on the stand. His tactic and strategy to help Mr. Davis with the guilt phase of the BP trial was to show that there are a number of firearms that could have matched this, that there was no firearm that was actually obtained that he could compare it to, and that he could not put that firearm in Mr. Davis's hand. And that is the argument that he made, and that was the argument that was available to him based on the evidence that was presented by the state. I would argue that the ballistics is not, quote unquote, the only evidence. There were witnesses who saw a car that matched Mr. Davis's car that was parked nearby the BP gas station, kind of backed into a cattle gate. There were a number of witnesses who saw that car. The tires were consistent with, the tire marks were consistent with the tires that were on the car that Mr. Davis was driving. It's another circumstance, certainly, that adds to the proof of his guilt. But Mr. Norgaard is a very experienced criminal defense attorney. He testified that he is never afraid to attack forensic evidence when he can. He did the investigation. He made a determination on the best way to attack the state's evidence, and his decision was to cross-examine Mr. Kwong regarding the number of firearms that could have been, and that they could not put any firearm in Mr. Davis's hand. And ultimately, his defense was one of misidentification. So in some respects, for that defense, it didn't really matter whether the bullets matched or not, because Mr. Norgaard's defense of Mr. Davis was, whoever had that gun, it wasn't Mr. Davis. And those are reasonable decisions that attorneys make all the time.
Do you agree or disagree with the characterization, though, of counsel having conceded that the same weapon was fired at both locations?
No, I don't think he did concede that, because his whole theory was, you can't tell me that it's not one of these 21 other firearms that have 6 lands and grooves and a right twist. So he didn't concede that necessarily. But obviously his theory was it doesn't really matter whether they matched or not, because it wasn't Mr. Davis. He didn't do this. If there are no other questions?
And do you think that's objectively an objectively reasonable
Absolutely,
defense?
Your Honor, absolutely. As I said, Mr. Norgaard's a very experienced attorney. He's been a defense attorney for over 30 years. He's board certified. He was involved in the development of minimum standards for death penalty for attorneys who represent death penalty defendants. He investigated this issue thoroughly, and he made a reasonable decision based on the information that was available to him. Thank you.
Thanks.
First, Your Honors, I would like to address the state's characterization of the other evidence against Mr. Davis in the BP case. Several days after the murder happened, they set up a roadblock near there and talked to drivers who'd driven by, and there was no one who said that that car that they saw parked into the back matched Mr. Davis's car. They said that it was similar and that they couldn't say for sure that that was his car. That would not be enough to convict Mr. Davis. The other issue that she talked about, the Nissan Altima tires. There was an expert who testified at the trial who looked at the tire impressions and gave the type of tire, I'm sorry, I don't have it in front of me, that was used, and that it was a very common tire, and it could have been on many different cars, including a Nissan Altima. So once again, that evidence would not have been enough to convict Mr. Davis. And also, Mr. Trial counsel did not have to hire the same kind of science expert that counsel brought to the post-conviction hearing. He didn't have to hire an expert at all. He didn't investigate thoroughly, because if he had, he wouldn't have felt like the only thing that he could do was talk about the type of gun. There were lots of other things that he could have done to poke holes in this type of evidence. And this was the only like forensics evidence that linked his client to the case. And just one other point that I would like to make, I want to make sure that we're not construing chronic with Strickland, because the Strickland standard is whether the representation was unreasonable in light of prevailing professional norms. And in this case, not challenging the state's, or not thoroughly challenging the state's only evidence against your client in a criminal defense case, in a capital case with 2 murders, is not reasonable in light of prevailing professional norms. Your Honors, I ask that you please remand this case to the trial court and grant Mr. Davis a new trial in the BP case. Thank you very much.
Thank you very much. We're adjourned.
All right.